Thank you, Peter. Yes, you can join us for the panel, and we have 3 more speakers for our panel. I'll introduce them one by one. Dr. Imke Sommer, who's Commissioner for Data Protection and Freedom of Information for what she called the smallest DPA on the planet, potentially. That is the city of Bremen.
Not on the planet, not on the,
Welcome.
In the European Union, maybe.
Maybe. Ted Dean, who's the head of public policy at Dropbox, and he used to work for the Obama administration before, for Department of Commerce at the intersection of privacy, data flows, and international trade. And Paul Gaskell from the Department of Digital Culture, Media and Sports of the UK, who's basically trying to get EU businesses ready for Brexit. Welcome, everyone. I'll join you as well. We'd like to make this interactive, so please feel free to interrupt us at any point. Just raise your hand if you have any questions, so that we can have a conversation rather than 4 little monologues. So please feel free to interrupt. Imke, I'll start with you if you don't mind. How is GDPR implementation going?
I think at the moment I am still celebrating the German the general data protection rule. I think it's really something we should celebrate, and we are working much because, for example, the number of complaints coming to my small DPA, but coming to other DPAs in Europe, all over Europe as well, has doubled. And that means that the GDPR has reached its goal. The goal was to be an advantage for the people whose personal data are processed. And if they really have the feeling, they can go to the DPA and they help them, and they really maybe get better rules. This is very good. And what is really obvious to all of us, I think, is that the GDPR is more efficient than all the laws of data protection were before. And I think this is a very good news. And it is very good news for the rule of law. And I think maybe the whole day through you talked about data protection, but I think we should talk about democracy. And we should talk about the rule of law, because this is something that really stands for democracy. And to see that a regulation is enforced, to see that it reaches the people that it is made for, this is a very good news. And I think all of us have to ask why. Is it stronger than the laws before? And I think one solution to this question is the role of DPAs. And I think this is what we have to talk about. And I think we all need, in these times, we need strong rule of law, the strong rule of law. We need to really follow the law, because this is what protects us all against things that are threatening our democracies. But we have to see that our roles changed. What really, maybe what the GDPR says is the same as before, more or less. What you have to do as processors with personal data is really the same as before. But it's more into force. And you know that more often we talk about fines, more often we talk about sanctions, and I think this belongs to this rule, to this law, and you can see that maybe at the panel before you could see it as well, that maybe the DPAs, they are growing. It's a big space the GDPR made for us, and we really have to grow into this space. But more and more you see that we manage to, that we are spreading our wings or something like that. And this is a very good idea, I think, and a good situation. But on the other hand, for this rule of law, which we need for democracy, you as the processors have to follow the law more, maybe as the times before, the panel before discussed about the negotiations between DPAs and processors. I think we should stop talking about things like that, because the roles changed. Certainly, here we are not talking about special cases. We can do it, but it's no negotiation thing. We have it was the democratic processes, and on the end there's the rule, and the rule has to be maybe obeyed and has to be followed. And all of us have to show this, and we really have to show it. And I think we have to show it because we are good examples for people who are doing hate speech, and there's no and in doing this hate speech they don't follow rules. We have to do it for some regimes who are autocratic and they are not following rules of law, and so I think what we are doing here, what we are yes, it's a new process. What we have for 15 months now is a very good opportunity to show that both sides, they really see it's for the best of all to see this is law and we do what the European Court of Justice says. And I think this is my statement, and I really want to show that the growing of the DPAs, it's nothing you should be afraid of. I think this is what all of us needed in the field of data protection. So.
Femke, I don't know about you, but I think it's the first time I'm hearing someone speak with so much enthusiasm about GDPR.
Yes.
I will move over to Ted, and I'm not going to ask you what's your opinion about the GDPR. You can, of course, go on and talk to us about that. But of course, there is a kind of renewed privacy law debate in the US, and there is some momentum for potentially passing some laws on that. What would be a timeline? What would be a content of those potential laws, in your opinion?
Great. Well, thank you for the question, which I'll, as artfully as I can, probably not answer, but I'll at least cover the topics in your question. I came to this event a couple of times when I was in government, and I really appreciate what Bitkom does here. And for me, coming from the United States, it was a great window into the state of the privacy debate in Germany. And so what I'll try to do is a little window into what we're seeing in Washington. I'll do that, obviously, sitting in a role at Dropbox, and I think it's important to just sort of lay our cards on the table first. We have a very strong interest in the US passing a robust federal privacy law. We believe that with the investments we've made in our privacy program, in part inspired by GDPR, but predating GDPR as well, that we'll be in a good position to comply with whatever the law is in the United States. And given our interest in a single federal law in the United States, and given the importance of data flows to our business, it's really important that Congress does act and pass a law. So I'll sort of, the rest of what I say will be more sort of an update on what we're seeing in Washington, but I think it's important to lay our cards on the table first. And so I'll try to talk a little bit about what are the sort of catalysts for this debate in Washington, what do we see as obstacles, and then try to answer your question with some predictions, perhaps. The catalyst, and the first, and perhaps one of the most important catalysts for this privacy debate in Washington is without question GDPR. And I'm not just saying that given the audience here, I think that's acknowledged in Washington too, that the passage of a comprehensive law in Europe, that the investments that companies have made in complying with that law already, and true for so many American companies that do business here, has really been a tipping point in the debate about privacy in Washington. We also, in the United States, have the passage of a new law in California, that is not as broad or comprehensive as GDPR, but in some cases actually goes further than GDPR in the sort of specific rights that it gives to users. It was, though, a law that was passed in great haste for reasons I won't go through here, but without a lot of consultation either with the advocacy community or with industry. And so I think many people, including in the advocacy community, not only companies, view it as a law that can be improved upon. And so there's been, over the course of the last few months, a number of amendments to that law passed even before the law went into effect. So everyone is sort of trying to look at ways to improve it. But that also has had an impact on the debate in Washington with the idea that if California passes a law now, if other states pass a law in the future, we sort of end up with a 1995 data directive type environment in the United States and not with a single law, single regulation for the whole country and people trying to avoid that outcome. And without question, the sort of privacy failures that, whether Cambridge Analytica or otherwise, that we've seen have sort of moved this whole debate forward as well. And so thinking back to my time in government in the Obama administration, we at one point put out what we called a discussion draft for federal privacy legislation. I think it's fair to say it was sort of dead on arrival. It prompted maybe a day's headlines and the debate moved on. Today in Washington, there's a really robust discussion about what privacy legislation should look like, what should be included. There are draft bills circulating. There's a number of real substantive efforts to come up with something and see if there's a way to pass it. All that said, there are pretty significant obstacles to passing it in short order. And I think also putting my cards on the table, I'm probably more conservative on the odds of something passing than many people in Washington. I think there are people in Washington who think we will see a federal privacy law in this Congress, and I'll sort of begin to tell you now why I don't think that's as likely. The first reason is this is just really hard. It took years to craft GDPR. These are complicated pieces of legislation. It's going to take time to run through that debate in Washington. There are also big substantive issues where there's not clear agreement. So in our sort of two-party split in the United States, there's significant disagreement on how preemption will operate, this idea that there would be a single federal law versus a series of state laws. So that's a tough debate to answer. Another debate about whether individuals will be able to bring a private right of action under the law. There's a significant debate about that. It's not clear that we'll get to a clear or get to a compromise on that issue. And then also, to be honest, the politics are just really hard in the current environment. Assuming there is going to be a law which includes preemption, we're then calling on the Democratic House of Representatives in the United States to pass a law with preemption. A significant part of the Democratic caucus in the United States is from the state of California, so they'd be preempting the law their own state legislature just passed. The Speaker of the House in the United States, Nancy Pelosi, is from California, so she'd have to preempt the law her state just passed. And so that's sort of a very concrete political issue. We're also obviously in a moment of divided government, and so getting Republicans in the Senate and Democrats in the House to agree on something, I think, will be complicated. And we're also in the midst of I think this is not a political comment, so I can go ahead and make it, simply saying that we have a painfully long election process in the United States without any comments on the participants in that election process, but it's a very long, so we've already started. So the window to reach a compromise, the window, again, just to put it in political terms, where the Democratic House in the United States may wish to pass something that might be viewed as a win for this Republican president to sign into law, I think closes very soon. So for all those reasons, I think it's difficult to get to a compromise in this Congress, which means this year and next year. Again, I'm probably more negative on that than some in Washington. And then so the question is sort of what's next? And so CCPA will go into force and companies will have to comply with it. And I think issues around its implementation will begin to surface. Other states will pass laws and they won't simply pass, I always like to say that in privacy compliance, it's not a dial. It's not that we can dial up to GDPR or dial further up for a new law. They often take us in different directions, and if different states in different ways don't just shorten the notice time period, but actually create new requirements, it'll be hard for companies to comply. And then also, I think there'll just be other developments in the privacy world. And one of the things people will watch was how further development in GDPR happens, and especially how fines come out and things like that. And so for my mind, if I had to make a bet, I think in a new Congress, potentially with a new president sort of shuffling the political deck, you could well see privacy law passed in the United States in sort of the 2021 period after our presidential election. That's a bet, not a certainty. But that's sort of the landscape that we see now. And again, I say that as a company that very much wants to see something pass. We're advocating for that now. We're publicly on the record, as many tech companies are, advocating for privacy. We created a new coalition of enterprise cloud companies in Washington to push for this. So we're very invested in seeing success, but sort of sharing my realistic assessment of the timing of success. So, thank you.
Thank you, Ted. Can I ask if anyone has questions at this time before we move on? Anyone wants to ask something about the DPAs, the US? No? Okay. Then from one hard politics place to another, we'll move on to, the B word. Paul, it's probably difficult to guess what will happen at this stage, but in a kind of deal and no deal scenario, in both situations, how do you see this, the kind of relationship between the UK and the EU moving forward in terms of data policy, data flows? Will we see an adequacy agreement?
Sure. So I can't match Dr. Sommer's enthusiasm, but we are also big fans of the GDPR. And it may be a bit of a cliche, but the UK will be leaving the European Union, but we're not going to be leaving Europe. And we've also made clear that when we do leave the EU, we will retain the GDPR as our legal framework. So we are committed. We're committed to high data protection standards. We think they are needed. The GDPR is not perfect, but it is a remarkable piece of legislation. And so we have already set into UK law the point at which we leave the European Union, whether with a deal or no deal. The GDPR will directly enter the UK legal framework. So that hopefully gives some clear certainty in terms of what UK law is going to look like. In terms of our future relationship, I think that's got two building blocks. One building block is going to be, as you say, adequacy decisions. So you will all know, of course, that adequacy decisions are the standard mechanism for the European Union to regulate its data protection relationship with third countries. So we are preparing for an adequacy decision. We're ready to go. We're ready to start tomorrow. We've been ready to start the assessment process for over a year, actually. And so we look forward to beginning an assessment with the European Commission as soon as we can. And given that we will have our domestic law that is in line with EU law, in theory, it should be quite a straightforward process. I suspect it won't, but there won't be. I very much doubt there'll ever be a third country that is closer to EU standards than the UK at the point at which we leave. The second building block is we're going to need some kind of agreement on cooperation between regulators. So you'll all be familiar with the ICO, a very fierce regulator. You'll have seen some of the eye-watering fines it's been handing out in recent months. At the moment, the ICO is a full member of the European Data Protection Board. Given that clearly we're leaving the European Union, so that relationship for the ICO will change, but given that we will have a legal framework that is based on the GDPR, then it's very important we have some kind of mechanism that the ICO can continue to cooperate with its European counterparts on the interpretation and the enforcement of that legal framework. If you're a business, if you're a business operating, say, in the United Kingdom and in continental Europe, you will not want that same legal framework interpreted and enforced in different ways by different regulators. So an agreement on regulatory cooperation is really important, and that is provided for in the GDPR, I think, by Article 50. So the destination of, I think, where we're going to land is pretty clear. What is going to differ is the route. I'm not going to get into the very interesting politics in London at the moment that I'm sure you're all watching very closely. As a good civil servant, I obviously wouldn't wish to do that. But clearly, a deal is by far the best route and is by far the easiest way to get to that destination. But ultimately, even if we left with no deal, my view is that adequacy and some kind of agreement of regulatory cooperation is where we're going to end up as well, but the path will be more challenging, shall we say. The only thing I would say is that it is pretty clear, if we leave without a deal, that there will be a gap between the point at which the UK leaves the European Union and the point at which we have adequacy decisions in place, and that creates a bit of a gap. If that situation so arises, the UK has said, well, okay, if you're a UK data controller, you can continue to send data freely from the UK to the European Economic Area, as you do now, pending permanent arrangements, but on a transitional basis. So that will give a clear basis for data flows from the UK to the European Economic Area. The tricky bit is going to be data flows from the European Economic Area back to the United Kingdom, and even though, because our legal framework will be the same, there'll be no substantive change to the data protection that is applied, technically, without adequacy in place, there is a legal breach. So it's very important, including for organisations and businesses in this room, just to make sure if you're exchanging personal data with a British partner, please have a conversation with them now about alternative transfer mechanisms, standard contractual clauses, that kind of thing, to make sure that that's in place by the 31st of October. I've spoken enough, I'll stop there, but I'm very happy to take questions.
Thank you, Paul. Any questions at this point from the room? Yes. Oh, sorry.
Good afternoon, Matthew Newman from MLEX. Question for Mr. Gaskell, particularly on this vexed question of transferring data to the EU. What will happen to the data that's already been transferred to the EU? And I'm talking about very sensitive police and security data that's transferred to Europol, for instance. Will that data have to be quarantined, or will all those people have to be alerted that their data, there's no longer a legal basis for sending that data? What's the contingency plan for that?
So that's an interesting question. So you're basically talking about the data provisions of the withdrawal agreement. You will be aware that the withdrawal agreement as a whole is still an issue of ongoing negotiation between the United Kingdom and the European Union, and the treatment and the data protection that applies on those data stocks, as we call them, is going to be part, obviously, of that ongoing discussion. But what I would just say, just to repeat, that the UK generally believes that high data protection standards is a good thing, and that our law, when we leave the European Union, will be based on the GDPR. So I think it is reasonable to expect that satisfactory arrangements will be reached to ensure that data is properly protected.
I don't see any other hands up, so we'll move on from Brexit for a little bit. And I want to return to Peter now with a very easy question. So, of like, what should governments do when they think of stricter privacy, but also kind of creating a fertile ground for innovation? How do you strike that balance? And I know it's the easiest question, and that's why I'm asking you that.
Well, first we should all wish Paul lots of luck. I mean, good luck with that. But the world's a big place, right? And the debate in privacy history has often been excessively transatlantic, in my opinion. It's been far too US, Europe centric. The internet users of Europe and US combined is less than half of China, to put it into perspective on a global stage. I've also been somebody who, for most of my career, had the benefit of seeing a world that was sort of converging on privacy standards. Obviously, the GDPR itself is a giant convergence within the EU. into a shared set of privacy standards. But even in places where the GDPR wasn't the law, companies, because they had to build one giant global compliance program to meet the GDPR, like my own company, Google, effectively were applying the same standards worldwide. Effectively, we were building one program to meet GDPR standards, and we're going to apply it everywhere. And then when I say everywhere, I mean everywhere. I mean Chile, I mean Japan, I mean, and for two reasons. One, because it's a great message to have the same level of privacy protection for people, your users, your customers worldwide. And two, much more practically, because it's devilishly difficult to try to run different programs to different countries. Now, I say I was privileged that we were seeing convergence on privacy, and largely we still are. This is a period over the last decade where we've seen more than half the countries on the planet pass privacy legislation, in particular in Latin America and Southeast Asia. Companies are driving global programs. But I think this is also a period where we realize there are always going to be some divergences. Brexit, regardless of what the outcome is, will drive some divergences within practices, whether they're divergences on paper or whether the divergences in regulatory enforcement, we'll see. But in any case, we'll have to live with that. One other thought about privacy, it's not just what's on paper, it's how it gets enforced. I think we all know that. And traditionally in Europe, well, the enforcement was spotty, can we say that? I mean, it varied dramatically from country to country. And the sanctions, if they were applied, varied dramatically from country to country, and in most places were relatively low. Under the GDPR, that's no longer true, at least again on paper, so we'll have to wait and see how that plays out. Meanwhile, and not waiting for what happens on paper, the Federal Trade Commission out of the United States has issued some jaw-dropping sanctions or negotiated sanctions, $5 billion, I said B for Facebook, as you may know, and just 2 weeks ago, 170 million for Google YouTube in a child's case. I mean, those numbers are much larger than anything we had historically ever seen out of Europe, dramatically larger, which tells me two things. One, the numbers in this space have gotten and will continue to get very big. The laws provide for them and they will be applied. That will come in Europe under the GDPR as well, even though there's perhaps a longer lag time in the enforcement process out of some of the countries. The ICO has gotten a bit ahead, but only in the narrow space of data breaches, so that's rather a unique scenario that I'd separate. And what does it all mean? Well, what it all means is we're moving to a world where privacy is going to be taken much more seriously than it was in the past, and where the expectation on companies, anyway, is to live up to these obligations much more consistently and seriously than they had in the past. And for people like us in this room who have made our careers in this space, that has to be something that we welcome.
Thank you, Peter. I can see Imke wanting to reply for the last half an hour. So would you like to kind of make a point?
Yes, I thought it was very interesting that you said it's such a big number of persons who want to have privacy at the Google mechanisms, and I think it's a reaction not only on the other rules, but it's a reaction on the fact that the gap between, I learned it, intention and behavior is closing. Very long, since very long time, everybody said, yes, I want to be I want to be very careful with my personal data, but they didn't. They wanted themselves to act, but they didn't. And the behavior was something other than the intention. And I'm watching this process for 10 years, and I really see the gap closing. I started with this discussion about Google Street View, and suddenly people who always said, I have nothing to hide, suddenly they saw there was the view of their house was something they wanted to hide from the rest of the world, maybe because it wasn't very nice at the moment when the car approached. And this is the time I started, and then it was Edward Snowden, and we have numbers that people really reacted on Edward Snowden in saying, now I really pay much more attention to my personal data. It was, I think, in Germany, it was a fifth or a fourth of all persons, and certainly it were the persons who said, I want to be more careful whether they were or not. And this is this gap. Yes, but now hearing it really is much more important to the people. And in Germany we had, and I think all over Europe last summer, we had this discussion about GDPR. I would say it's the first abbreviation which really is known all over the society. In Germany is this, was ist es? Vor dem, after GDPR heißt DSGVO, meine Güte. And everybody, if I talk to people, they really use the abbreviation because they know it's got something to do with their rights, and they use it. And to hear that they really practice, they don't want themselves, they don't only want themselves to behave, but they behave. This is really very good news because it shows that they are self-confident, that they really know they have this right, this human rights, but they really behave and they use it. And this is for my subject the strengthening of societies against some things that are going not on the right side, that are not going into the democratic side. This is very important, that the people feel it's for them, and this is why we have to take our roles very serious, both of us, both sides.
Yes. So considering that citizens everywhere seem to have similar concerns, or consumers, whichever one you want to call people, what do we do with the whole political framework around how do we talk to each other, considering the hard politics and like where multilateralism is these days, so that not necessarily regulatory convergence, because we have very different systems and legal systems in our countries, but how do we keep that conversation going in a world that seems to be building more walls around countries than dialogue? Maybe Ted, you want to pick up on that?
I'll make a small comment first, which anticipate a little bit of your question and then try to answer it. I mean, the first thing I would say is I think everything you described about people having a better understanding of their rights and being more focused on privacy and their behavior getting closer to their sort of intent, I think is also a description of what's happening in the United States. And I won't put you on the spot, Peter, but my guess is there's a lot of US Google users using those controls you described, and those percentages are very, very high in the United States. And so I think in having just sort of given a maybe pessimistic view of the US Congress, I think it's important to remember that on this issue, as on many, the US Congress is a bit of a trailing indicator on where the United States is. And so I think the citizenry and users have come a long way in terms of thinking about privacy in a more sophisticated way and thinking about their rights. Also, fortunately, and for confidence in the US legal system on this, the enforcement agency is ahead of where the US Congress is. And so the fines that Peter described, I think, should give more confidence that there's sort of a cop on the beat in the United States on these issues. I will say more to your question about how do you get countries talking together about this. I don't think there is a magic formula on that. From when I was in government, I think we were in the immediate post-Snowden aftermath, and so the conversations about this were particularly charged, particularly difficult to drill down to sort of facts that we could agree on, and so that was a very difficult time to make progress on these issues. But I also think, and Alex, who was up here earlier talking about the Privacy Shield annual review, I think what he described of, we went through that multi-year negotiation process, learned from each other. They've now done 3 annual reviews, built trust, been through that process. It really is just sort of proof of it requires investment and it requires time to do that. And I think also very much agree with Peter's comment about it. There's a tendency to focus on a transatlantic basis for this. I think some of the work we did when I was in government around APEC and looking at how do we deal with other countries about data flow issues was really important. But I think ultimately there's no substitute for sort of sitting in the room and trying to understand each other. And then hopefully you get to some point where you can find not convergence, but an understanding that's a basis for what comes next.
Thank you. Now we've got about 10 minutes to go, so this is another chance to ask questions in the room, if anyone has any. No? Good.
Can I just make one additional comment, actually, in the answer that Ted gave about how we I guess, join up better. I think the one thought I've had really is that I think we need to make sure that we focus on the outcomes and the high level of data protection outcomes that we want to achieve, and less on the process of how we do it. And it sometimes feels to me, in Europe at least, that we have a sense there's a very set process and framework. It must be done this way. So we focus on the process, not the outcomes. And I think if we focus a bit more on the outcomes and less on the process, we will find it easier to find mechanisms globally where we can join up and protect data standards more effectively. That's just my quick thought on that one.
Thank you, Paul. So, for the last 9 minutes of this, we'll go around the panel again, and you'll make your final remarks. But my kind of question for all of you is how do we move forward from here? We've kind of run through the challenges of where our world is right now and the hard politics of various countries, most countries. Is how do we actually move that conversation forward, and what is the role of government, industry, society as a whole? We've seen that citizens are kind of ahead of the discussion. How do we move forward together in such a way that stops being a kind of European conversation, a US conversation, a Japan conversation, but it becomes a kind of truly global framework for that conversation and that policy to move forward? Thank you. You can start in whichever order, Peter.
Okay, so I'll start. Look, if you're in the tech industry, you're running a global business whether you like it or not. If you're on the internet, everything you do is instantly global. So in a world where there's nobody in charge anymore, and where a lot of the multilateral institutions are perhaps taken a step back, that's created a bit of a vacuum. But that vacuum is going to be occupied by companies that have to make decisions and do something on a global basis. This is not a power grab, it's a reality of a statement. I mean, we are going to build stuff, and we are going to launch stuff, and so will our competitors, that will be done globally, and it will set a certain standard. And people will either say, okay, that's the right standard, or it's not quite the standard I would like, but we will not wait to have an 8-year conversation around a COC, as in the prior panel was being discussed. That just isn't realistic. So we have to be a force for multilateralism. We have to be a force for globalization, because it's just in the nature of the business of what we do. Now, that being a statement of fact, I am a profound believer that the dialogue needs to be inclusive with multiple stakeholders and different governments around the world. And God knows I bust my little jet lag butt to run around the world talking to people. So, I'm doing the best I can, and I know a lot of my colleagues at Google are doing the same thing. But, that's it's just a reality of globalization, that this field will move fast. That's just the nature of how it operates. It will. And it will not stop to have 10-year conversations about stuff. That's another reality. So, I'm being very blunt. I think we need to have this multi-stakeholder debate, but I think a lot of things are holding it back. And the timelines are somewhat complete mismatch between the industry and the timelines according to which we operate. and the conversations that can be sort of more philosophical or procedural based. I would love there to be more and more dialogue. I think there needs to be. I'd be the first person, and you can even quote me on this. I do not think the great ethical and legal issues of our day in the field of privacy should be decided by the engineers working at tech companies. Does anybody here think they should be? Because I don't. So I have this open-ended invitation to have a deeper dialogue around the world, but it's got to speed up, and it's got to, just got to kind of get on the train at the speed at which the train is moving.
Yes, I think we heard good news. Google sees the GDPR as a global standard. Brexit won't change the rules of data protection in maybe a little, but in UK. And I think this is very logical because it's the inner logic of data flows. It's global, and it's the inner logic of data flows with personal data as well. So this is what is really not astonishing, but it's as well very nice to hear. And I think the best we can do for the world, for the democracy, for just having a possibility to guide what's happening is really to keep in mind it's about persons, it's about human beings, and always to have them in mind and maybe do something more than you have to. Even it's better than to do less than you have to. And I think keeping this in mind, maybe this wouldn't be the thing that makes the world worse.
So I want to stand between you all and beer and pretzels for as short a time as possible, so I'll be brief. I think that as clearly we've invested a ton, as many companies have, in GDPR compliance. You talked about the rule of law, and certainly if the rules are clear and on the books, we're going to follow them. That's what we have to do as a business. I think the next step that you talked about, which I agree with as well, is at a company like Dropbox, just making sure that we remain focused on what our users want, what they expect of us, and the trust we build up with them. And as long as, and that happens today, and as long as that remains sort of the notes that we are tuning to at a company like Dropbox, I think we'll do very well. But I think that's where, as an industry, we need to just continue to be thinking about designing from the perspective of what is the trust of our users, and how do we keep it.
Similarly, a very swift last thought, because I'm much looking forward to the beer as well and the pretzels. My final thought is that we shouldn't define data protection in opposition to other things that governments need to do. So, for example, it is data protection and free trade can go together. Now, clearly, data protection should never be a tradable good in trade agreements, but you need to have high standards of data protection to create public consent that is required for the data flows that will underpin free trade, for example, and we believe that free trade is generally a good thing. Similarly, data protection should not be in opposition to the role of governments to protect the security of their populations. It's entirely possible for democratic governments to have high data protection standards, but also data sharing for law enforcement and security cooperation that is clearly democratically grounded and transparent in law, and you can do both. So I think my final thought is data protection, we need to be able to walk and chew gum and deliver other priorities of government. It shouldn't be defined in opposition.
Thank you, Paul, and thank you, everyone. Would you mind joining me in thanking the panel for their insights?